The views and opinions expressed by the host do not state or reflect those of the company and its management. Furthermore, the views, opinions, and insinuations made by the host, guests, do not reflect those of the show, the management, and the network. Magandang gabi, Pilipinas. The impeachment trial moves forward, but the questions are getting harder to ignore. Days 14 and 15 put confidential funds, questionable receipts, and accountability under intense scrutiny. Inside the Senate, testimony and evidence faced tough cross-examination, while prosecution and defense clashed over the conduct and pace of the trial. Because in a political battle where public trust is at stake, every receipt matters. Every answer counts, and every move has consequences. I'm Ox Ballado, and this is the PH Insider on TV. Tonight, we take a closer look at the legal and the constitutional questions behind some of the most pressing issues on the trial of VP Sara Duterte. Joining us is a seasoned human rights lawyer and a strong voice for legal accountability and constitutional integrity. He is the national president of the National Union of People's Lawyers and a longtime advocate for marginalized sectors and human rights. Please welcome Attorney Ray Cortez. Attorney, good evening.
Good evening, Ox. Good evening, Professor Encarnacion. And it's a pleasure to be with you tonight.
Yeah, thank you for joining us tonight. To complete, of course, our panel, we are joined by one of the country's most sought-after political analysts. He is the chairperson of the Department of Political Science at the University of Santo Tomas and a respected voice in national political affairs. Please welcome our resident political analyst, Professor Dr. Dennis Coronacion. Good evening.
Good evening, Sir Ox. Good evening, Attorney Ray. Good evening to everyone.
Long time no see, huh?
Oh.
All right. Day 14 of the impeachment trial brought more questions over confidential funds, questionable receipts, and accountability. From testimony inside the Senate to the heated clashes between prosecution and defense, the proceedings continued to put the evidence and the players under intense scrutiny. To give us the key highlights and the developments from Day 14,
Sa pagpapatuloy ngayong hapon ng ika-14 na araw ng impeachment trial ni Vice President Sara Duterte, kakulangan pa rin ang supporting document sa liquidation ng OVP ang binigyang diin sa testimonya ng testigo. Ayon kay COA ICFAO Auditor Sailin Del Campo, naglabas ang kanilang tanggapan ng Notice of Disallowance matapos lumabas sa pagdinig ng Kamara noong 2024 ang pahayag ni OVP Special Disbursing Officer Gina Acosta na inutusan siya ni Duterte na i-turn over kay Colonel Raymond Dante La Chica ang cash advance para sa confidential funds. Giit ni Del Campo, paglabag ito sa joint circular dahil ang nakatalagang special disbursing officer lamang ang dapat humawak at mag-disburse ng confidential funds kung saan hindi umano maaaring ilipat ang naturang responsibilidad sa ibang opisyal. Inilahad din ni Del Campo na kabilang sa mga dahilan ng disallowance ang 62 million pesos na reward payments na walang sapat na dokumentong nagpapatunay sa naging resulta ng information gathering at 199 million pesos na gastos para sa mga supplies, medical at food aid na hindi umano ma-verify. Sa pagsusuri naman sa acknowledgement receipts, napansin ng COA ang magkakaparehong petsa ngunit magkakaibang lugar ng transaksyon, kabilang ang Davao City, Masbate, Lawag at iba pang lugar. Ayon kay Del Campo, ang lugar sa resibo ang dapat tumukoy kung saan aktwal na binayaran ng pera. Samantala, sa confidential funds ng Department of Education, sinabi ni Del Campo na si Edward Fajarda ang itinalagang SDO na dapat mag-disburse ng pondo. Isinumite rin ng DepEd ang 1,180 acknowledgement receipts at iba pang dokumento, kabilang ang certifications mula sa Armed Forces of the Philippines. May 180 days ang OVP upang umapila sa Notice of Disallowance ng COA matapos matanggap ang naturang notice noong March. Mula rito sa Senado, ako si Gazi Sare para sa DATV News.
Let us now begin our discussion with our panel. Let me begin with you, Attorney Ray. Let's talk about this COA testimony. They identified expenses that were not allowable under the rules on confidential funds. How significant is this to the impeachment case? Ano po ba kahalaga ito?
Well, this is the meat of the case for the prosecution, especially on Article 1, because this is the mishandling of the confidential funds. The joint circular is very clear on how confidential funds should be disbursed. It should be disbursed in accordance with the enumerations I stated, and it should not go outside that enumeration. So obviously there are items that are not in accordance with the enumeration allowed by the COA, and it's there that the meat of that violation is. Regardless of how you look at it, insofar as disbursement is concerned, there's already a violation. And you're not talking about auditing requirements, because that's another violation here.
Yes.
And you have the fictitious names.
Yes.
That's the third violation. So if you look at it, the Office of the Vice President and even the DepEd violated the disbursement requirements, and at the same time did not comply with the proper procedure for auditing. And you can see there, using fictitious names is just a proof that there was misappropriation of the confidential funds. And I think you need not prove that the Vice President personally benefited from the funds, because they're, as testified to by the witnesses, once it is proven that there's regularity in the disbursement and auditing, the presumption, according to the joint circular, is that the head of the agency benefited from the misappropriation.
So, yun pala yung ina-assume doon. Okay. Baka meron kang gustong idagdag.
Actually, may tanong ako kay Attorney,
go
kasi
ahead.
it was shown in the testimony of the witness. I think that was Attorney Wamil. Oo.
Yes, yes.
He stated that based on the ARs, a portion of the fund had gone to, say, the purchase of chairs and tables. And there was also some ARs pointing out that medicines were purchased or given to a certain person whose identity is not revealed, real identity was not revealed. Pero it turned out na the amount was allotted for the purchase of medicines. Are these justified under the joint circular, Attorney?
Well, the purchase of medicine itself, as testified to by the COA auditor that testified yesterday, the lady COA auditor, it's not allowed under the joint circular. But what should be considered is that what they're claiming is that this is a reward. The medicine purchase is in the form of a reward to an informant. But the problem there is, as testified to by Attorney Wamil, is that before you can avail of the confidential fund, you have to submit a physical and financial plan. And in the physical and financial plan, you have to cross-match a specific disbursement and the purpose for the disbursement. And Attorney Wamil pointed out when he testified that there's no specification as to how it would be disbursed as required by the COA, by the joint circular. So that's where the problem is.
So there will be no basis of...
At all, yes. It was just from the time to disburse, there's no basis that it will be used for confidential purposes. Because confidential fund is specifically defined for confidential purposes. And for chairs and obvious, as testified to by the lady auditor yesterday, it is definitely not covered by confidential expenses.
Okay. Now let's talk about if this particular aspect. If the operation is confidential, how far should that confidentiality extend when it comes to the use of public funds?
Confidential in the sense that,
Kasi sabi, ang operation has to be confidential.
yes,
Oh.
meaning for auditing purposes, you cannot disclose the identity of your informants or the specific address of your safe houses. But let's say if you will purchase grocery items for your informant or purchase medicine, you have to submit proof that there was such purchase, the official receipts. Because where you purchase it is not confidential. But of course, again, you go back to the physical and financial plan submitted. Is the purpose stated there? Because you have to disburse your confidential funds in accordance with your physical and financial plan. So, of course, what was emphasized yesterday are expenses, let's say, for Christmas party and awarding ceremony attended by the Vice President. And whether the confidential fund should be used or the regular fund for the Vice President should have been used to, let's say, secure the Vice President during those events.
Attorney, let's focus on the identities of the recipients of these confidential funds. Since we're talking about the extent of the confidentiality allowed in terms of disbursing these confidential intelligence funds, alam na ang mga nakita natin yung mga fictitious names or mga pseudonyms like Mary Grace Piatos. Does our law allow that there should really be no that their identities should not really be revealed to the point na wala man lang records about them, about these recipients?
Definitely, there should be records maintained by the agency concerned. So here is the Vice President. Sabi nga ni Attorney Wamil when he testified, there's nothing in the circular or the law that prohibits the use of pseudonym pagdating sa informant. In fact, ano yan, standard practice yan so as not to reveal the identity of your informant. But again, there should be a certain way to verify the expenses. Now, the problem now with that came out yesterday during the cross-examination of the lady, the witness, is that a single person signed the disbursement vouchers in several places. Which at the same time, it makes it impossible. Sabi nga ni Attorney Kapunan, Superman. So, meaning, let's say Mary Grace Piatos itself, hindi na siguro yan katakataka. Pwede mong palagpasin yan. Pero if you disburse hundreds of disbursement receipts in a single day, in different places, done by a single person, that's where the problem is.
How strong is this as evidence of irregularity? Pwede ba siyang gamitin or talaga mabigat ba to?
Taken alone, pwede pa lumusot.
Okay.
But if you take it in light of the other circumstances, that's where the problem is. Kasi doon makikita whether it's just a pseudonym or there was really irregularity. So you have to look at the fiscal and financial plan. You have to look at how these were disbursed. So, taking all these circumstances, doon mo makikita kung ano itutulong niya doon sa case ng prosecution. It will bolster yung kanilang position that there was misappropriation of confidential funds. Taken alone, pwedeng sabihin na it's not an evidence of misappropriation by itself. But if you take it in the light of the other circumstances, that's where misappropriation can be proven.
So, it's like saying, Attorney, it's, the use of the aliases alone is not a source of irregularity. Kasi that's allowed.
It's allowed eh.
It's allowed.
Under the
So long as it can be also
verified.
Verified, that's right.
Yes.
Kasi pag nag-appropriate ka nga naman ng pondo doon, nag-disburse ka ng pondo doon, pwede mo kung hindi ma-verify, pwede mong gawan lang eh. I mean,
Oo.
di ba?
Yeah. Pero if you put it together with the other acts of the respondent, then dun siya nagkakaroon ng problema.
That's right.
Yes.
Okay. Well, some receipts also carried names resembling to those of current and former senators. May mga ganun. So, what would prosecutors need to establish before these names can be considered significant evidence?
Again, na-elay na nila yung basis.
Okay.
Of course, Attorney Wamil already pointed out about the fiscal and financial plan that had been stated, the purpose, cross-matching the purpose and the items for disbursement. And the other witnesses also testified on what are the documents that are acceptable to the COA during the audit process. And by the fact that they issued an AOM,
Okay.
it means that the audit documents were not acceptable, not in accordance with the requirements of the joint circular. So that's where you can now connect the dots that there was irregularity, not because they used the pseudonyms or the fictitious
because
names,
of,
but because of irregularity in the disbursement and in the way they liquidated the expenses.
Yeah. Ako naman, attorney, I have another question. The prosecution claims that the defense may be delaying the trial. So how do we distinguish a legitimate defense strategy from a delaying tactic?
Siguro yung perception na yan nandun yung sa kanilang refusal to stipulate.
Yeah.
Because I
The
remember
ARs.
Attorney Kapunan proposing to the defense that they stipulate on, I think, several hundreds of ARs.
ARs, yeah.
But they were not able to do the stipulation. Instead, they're not doing it, the documents being identified by the witness one by one. Well, it's you can say it will generally prolong the proceedings since you have to go through each and every document. But at the same time, I think the defense is also entitled to such a procedure because it's also required that each and every document should be authenticated by the witnesses, so that you cannot force the defense to enter into a stipulation. They can only enter because it should be voluntary.
But this should have been done during the pre-trial stage.
Well, that should have been done during pre-trial stage, and that's the reason why there is pre-trial in the first place.
Yes.
To simplify everything.
That's right.
So that you don't have to prove something that you both agree happened. So that you will limit now the trial to matters and facts that you disagree whether it happened or not.
Which saves times as well, right?
Yes.
Yeah. But how critical do you think is this comparison of thousands of acknowledgement receipts to the prosecution's case?
Well, this is the meat of the prosecution's case.
Yes,
You have to
But it's always
establish
crucial,
the
right?
when it comes to documents, you have to establish three
Yes,
things:
okay.
authenticity, existence, authenticity, and due execution. If you're not able to establish one of the three, it cannot be admitted as evidence.
So all of those three should be present.
Yes, it exists, it is authenticate, and it was duly executed. That's why if you observe how Attorney Kapunan questions, confronts the witness with the ARs, because she wanted to prove all the three circumstances.
Oh, okay.
Sige. Eto, attorney, yung prosecution kasi also raised the sub judice rule over the vice president's public statements. What are the limits of public commentary while an impeachment case is ongoing?
Malinaw naman ang sabi ng Supreme Court pagdating sa sub judice rule. If merong danger that the impartiality of the court will be affected, ay maging contumacious or yung act na yon.
Yes.
Because it tends to degrade the integrity of the court and it affects how the court decides the case. One of the factors that we should consider when we discuss sub judice rule in relation to impeachment trial is that according to the Supreme Court, impeachment is a sui generis.
Yes.
It's it's said constitutional and legal, but at the same time political.
Yes.
And the judges are not your judges in the judiciary,
Yes.
but politicians. So that's where it's very difficult to determine whether can you comment on what's going on when it's a political
On a specific
exercise.
aspect of the
Yes,
process. Right?
yes. So I think as long as it will not affect the independence and the impartiality of the trial, the court, that's the
So that's perfectly fine.
that's the rule. Yes, but impeachment. At the end of the day, it will be decided by numbers,
Yes,
not
exactly.
on how the judges will perceive whether the prosecution was able to prove their case or not.
Yes.
So, nandun yung difficulty in saying na mag-apply ba yung sub judice. To me, sa political nature ng isang impeachment trial, I don't think that you can impose a sub judice rule.
Speaking of public statements, Attorney, no? Yesterday, I think one of the defense lawyers called the attention of the presiding judge over a Facebook post of a prosecution lawyer who seemed to post something that's related to what took place yesterday. It has something to do with the misleading question
on what transpired
during the cross-examination.
Yes.
Is that can that also be covered by the sub judice rule, or can
Is there a
at least
technicality?
something be done about that?
Are there
Oh.
technicalities when it comes to that?
The complication there is that he is a private prosecutor
Yes.
in the case. And he was commenting while the trial is ongoing. I think it's a few minutes after the exchange transpired. But again, if you look at his post, it's a statement of a general principle in evidence that misleading questions are not allowed. So there's nothing there that will impede the administration of justice. There's nothing there that will affect the impartiality or of the court or the integrity of the impeachment court. Not even a slight on the other counsel, because it's just a statement of a general principle that contradicts what the other counsel said.
Yes.
So medyo
Gray area.
Gray area.
To my mind, it was some sort of an enlightening statement. You know, however it was intended. You know, by the lawyer, by the good lawyer. But pwede naman yun. It's just so happening nga dahil part siya ng proseso. No? In fact, marami natuto. Isa na ako na nabasa ko yun. Sabi ko, okay, yun pala yun.
Pero Attorney, are you in favor of, I think, the proposal of the defense panel that these commentaries should be regulated?
Siguro among those involved in the trial.
For delicadeza, I think.
For the defense and the prosecution. So that they will ventilate whatever views, comments in the trial itself, not outside.
Correct.
But for the others, I think there should be no gag order.
Yeah. Okay.
Kasi it might be too personal din pag if the post is something that kind of, let's say, belies or attacks the
or insult someone. Yeah.
So you don't litigate your case.
outside.
Outside.
All right. From confidential funds to questionable receipts, Day 14 has raised serious questions on accountability, evidence, and the limits of political power. But there's more to the story. We'll continue the discussion and break down the legal and political implications after the break. Stay with us. This is the PH Insider on TV.
Narito na ang schedule ng inyong paboritong Lotto games mula sa Philippine Charity Sweepstakes Office.
Araw-araw ang draws ng 2D Lotto at 3D Lotto tuwing alas 2 ng hapon, alas 5 ng hapon at alas 9 ng gabi.
At pagsapit ng alas 9 ng gabi, sasamahan pa yan ng big time games. Tuwing Lunes, magpapapremyo rin ang 4D Lotto, Mega Lotto 645 at Grand Lotto 655.
Pagdating ng Martes, magdadala ng panalo ang 6D Lotto, Lotto 642, Super Lotto 649 at Ultra Lotto 658.
Tuwing Miyerkules, umaarangkada ang papremyo ng 4D Lotto, Mega Lotto 645 at Grand Lotto 655.
Pagsapit ng Huwebes, tutok na sa 6D Lotto, Lotto 642 at Super Lotto 649.
Mapapanood naman tuwing Biyernes ang pagbola ng winning numbers ng 4D Lotto, Mega Lotto 645 at Ultra Lotto 658.
At tuwing Sabado, abangan ang 6D Lotto, Lotto 642 at Grand Lotto 655.
Sigurado namang pasasayahin ang araw ng linggo ng exciting prizes ng Super Lotto 649 at Ultra Lotto 658.
Sali na dahil baka ikaw na ang susunod na mananalo
At maging Lotto Milyonaryo. Araw-araw, let's play Lotto! Dito lang yan sa DATV at IBC.
Day 15 brought another round of contentious testimony and heated exchanges inside the impeachment court. From questions over the handling of confidential funds to disputes over acknowledgement receipts and social media posts, the proceedings put both evidence and conduct under scrutiny. To walk us through the key moments and developments from Day 15, here's Judea Bernardo.
Tapos na ang ika-15 araw ng impeachment trial ni Vice President Sara Duterte at nananatiling nakasentro ang diskusyon sa Article 1 o alleged misuse of confidential funds, questionableng pag-liquidate ng mga dokumento nito at ang umano'y misappropriations ng mga opisina ng Vice Presidente sa nasabing pondo. Kinwestiyon ni Ferrer kung may natuklasang finding ang COA na nakatanggap ng bayad para sa reward at purchase of information ang Vice Presidential Security and Protection Group o VPSPG. Sagot ni Del Campo, wala. Tinalakay din ang mga acknowledgement receipts na ginamit sa liquidation ng confidential funds. Nang itanong ni Ferrer kung ang mga pangalang gaya ni Mary Grace Piatos, Renan Piatos, Ralph Josh Bacon at Andy Lim ay automatikong nagiging fictitious dahil kakaibang mga ito, sinabi ni Del Campo na hindi niya ito masasagot. Ipinaliwanag din ni Del Campo na hindi sinasagawa ng COA ang verification ng identity ng mga payee. Compliance audit aniya, ang mandato batay sa mga dokumentong isinusumite. Sa cross-examination naman, binigyang diin ni Ferrer na independent agency ang COA habang kinwestiyon niya kung bakit isinama sa audit ang mga impormasyong lumitaw sa mga pagdinig ng House Committee on Good Government and Public Accountability. Ayon kay Del Campo, kabilang sa mga impormasyong maaaring gamitin sa audit ang mga admissions na ginawa sa ilalim ng panunumpa. Bago magtanghali, tinalakay din ang 75 million peso confidential funds ng Department of Education na nakatanggap ng credit notice noong August 8, 2024, matapos makapagsumite ng compliance ang ahensya sa ilang findings ng COA. Sa redirect examination, tinanong naman ni House Prosecutor Counsel Attorney Lorna Capunan si Del Campo kung kasama ba sa mandato ng OVP at DepEd ang mga confidential activities. Sagot ni Del Campo, batay sa mandato ng dalawang ahensya, hindi ito kasama. Kinwestiyon din ni Capunan kung maaaring gamitin ang confidential funds para sa mga personal na aktibidad ni Duterte at sa security ng Vice Presidente. Ayon kay Del Campo, hindi maaaring i-charge sa confidential funds ang mga personal na aktibidad. Kabilang sa mga binanggit ni Del Campo na hindi pinapayagan sa ilalim ng Joint Circular 2015-01 ang Christmas party, tree planting, council meeting at pamamahagi ng groceries kapag ito ay siningil sa confidential funds. Tinapos ni Kapunan ang redirect examination at muling nag-cross-examine si Ferrer. Dito kinumpirma ni Del Campo na walang finding ang COA sa Notice of Disallowances na nakatanggap ng reward o payment para sa purchase of information ang VP-SPG sa confidential funds. Iginiit din ni Ferrer na inaprubahan ng Office of the President at ng Congress ang confidential funds ng OVP. Tinanong niya kung may tuwirang prohibition ba sa Joint Circular na hindi maaaring tumanggap ng confidential funds ang OVP at DepEd. Sa pagtatanong naman ng mga Senator Judge, sumentro ang atensyon sa 16 million pesos na ginastos ng OVP para sa 34 safe houses sa loob lamang ng 11 araw noong 2022. Tinanong ni Senator Raffy Tulfo si COA State Auditor Del Campo kung excessive ba ang 16 na milyong pisong paggasta para sa mga nasabing safe house. Ayon kay Del Campo, umasa lamang ang COA sa certification ng Special Disbursing Officer na kinakailangan ng mga ito at may legal na layunin. Inamin naman ni Del Campo na malaki nga ang mga nasabing halaga para sa pag-upa. Ayon kay Senator Tulfo, kung hahati-hatiin ang halaga, lumalabas na nasa 42,780 pesos kada araw ang gastos para sa bawat safe house. Samantala, sa labas naman ng Senate Impeachment Court, iginiit ni prosecution spokesperson at Lanao del Sur 1st District Representative Zia Lonto Adjong ang isang tanong. Bakit kailangan gumastos ng milyong-milyong piso para sa security-related activities sa Davao City kung ito na ang itinuturing na pinakaligtas na lugar para kay Duterte?
At saka, the safest place for her is Davao City. Di ba? Why would spend for money in an area where you feel the safest?
Ayon pa kaya Jong, base sa testimonya ni Del Campo, lumalabas na ang pinakapakinabang ng confidential funds ay para sa seguridad ni Vice President Sara Duterte at hindi direktang sa pakinabang ng publiko. Mula rito sa Senado, ako po si Judea Bernardo para sa DA-TV News.
All right, thank you very much, Judea Bernardo. Let's now examine what these developments could mean. Let's begin with Attorney Ray again. Kasi sinasabi po ng COA, itong COA auditor, that transferring confidential funds from one disbursing officer to another can break the chain of accountability. I mean, legally, Attorney, how serious is this?
Very serious, gaya ng pinoint out nung COA auditor yesterday, na it's part of the internal control. So that's why it's required that there's only one SDO to disburse the confidential fund, so that they have control on how it is disbursed. Now that it is being disbursed by the person other than the SDO, that's where the problem is. It's irregular, since that other person is not the one authorized under the circular, joint circular, to make the disbursement. And these public funds, it can be disbursed in accordance with the requirements imposed by law and regulations. And the regulation says it should be disbursed by the SDO. Now, if it is disbursed by persons other than the SDO, who is not authorized under the circular, then that's irregular. And there's a problem regarding internal control.
There's another, actually, Attorney, since you mentioned the SDO, there's another issue rising from that one. So if one person is designated as the special disbursing officer, but payments are made in different locations simultaneously, what accountability issues does that create?
Well, irregularity in the disbursement, and therefore, the one accountable there is the head of the agency. It's a matter that who controls the operation of the agency. Definitely, it's not the SDO. It's the head of the agency. And if there is accountability, and that's misappropriation, that's malversation of public funds if it's not properly accounted for. And there's such thing as technical malversation. And there's such thing, may mga na-convict na recently lang ng malversation through negligence. So, pwedeng pumasok sa ganon. Not to mention, of course, this impeachment trial, it pertains to the fitness of the Vice President to hold the office or not.
So that also applies, that can possibly apply in the impeachment trial.
Yes.
That even though it's not the Vice President who personally disbursed these funds, but rather the SDO and the others, siya pa rin ang doon, posibleng liable.
Because at the end of the day, he is the one liable for that funds. Malinaw yun sa joint circular nang sinasabi ang liable is the head of the agency, which in this case is the Vice President.
Tinaalala ko, attorneys, yung during the interjection, si Senator Amy Marcos, she mentioned something about that, na it was not the Vice President who personally received the allocations, but rather the SDO. So implying na hindi liable si Vice President.
But the authority of the SDO comes from the office of the Vice President.
Yes. Okay, attorney, meron din sinasabi yung auditor na confidentiality does not necessarily cover where medicines, food, and supplies were purchased. In fact, if I may just ask, how should this balance be struck between operational secrecy and public accountability?
Well, operational secrecy maybe refers to where is the safe house is, or the identity of the informant. But when it comes to where you purchase grocery items and medical supplies, that's not confidential. There should be proof on how you purchase it.
And also the birthday party.
And the birthday party.
Baka yun ang dapat confidential. Okay, so what would be the prosecution need to establish before these acknowledged receipts naman, itong mga resibo, no, can be considered as proof or fictitious nga, or irregular transactions?
From the way the trial is going on, they simply had to present all the ARs.
Okay.
And apparently, it's apparent from the ARs that these were not properly disbursed. Pinopoint out ni Attorney Kapunan whenever she asked the witness to identify a document, let's say the date of disbursements and the signatures. At lalabas naman traces doon. I mean, I think there are findings that there were only 7 persons who signed the document because of the similarity in signatures. And of course, the date that these were released. For example, there is an issue where the disbursement came before the release of the confidential fund to the office of the Vice President. So these are all irregular and this is apparent on the documents. So what the prosecution should simply do is to present all this document, and from there, mapuprove yung irregularity, mapuprove yung misappropriation. This is a case where you rely on the documents to prove your case.
All right. Attorney, let's move on. Let's move on to another aspect of the impeachment trial. So day 15 also saw the heated exchanges between the prosecution and the defense. How much does courtroom conduct matter in an impeachment trial?
Well, they're both lawyers. Ethical considerations require them to respect each other.
Yes.
Courteous. Of course, we heard some spanking or lecture you. I think those should not have been said.
Okay.
And also, of course, the response of the other lawyer to the way she responded to Attorney Kapunan is much to be desired also. But well, generally, they're both good lawyers.
Oh, yes.
It's just that they need to control themselves from time to time.
So self-restraint is expected from these lawyers.
Yes.
Kasi maraming mga side comments, attorney.
Balikan lang natin itong social media post. Because well, si presiding officers, si Senator Chis Escudero even warned that one side had been crossing the line, with the social media posts. Where should the line be drawn between political communication and conduct that could affect the integrity ng trial dito?
Well, nobody from those involved in the trials would comment on the merits of the case, meaning whether the defense was able to produce sufficient evidence, or that
Especially outside the court.
outside the court.
The impeachment court, rather.
Those should be prohibited.
Uh-huh.
But of course, when it does not affect how the judges will decide on the case, that's where the thin line between freedom of expression and subjudice rule comes in. So that, kasi ako, mas nandun ako sa let them express their feelings. Nandun ako sa freedom of expression. Pero it should be balanced. Katulad nung post ni Senator Alan Cayetano, di ba? So,
Siya daw ay neutral.
meron ding ganon.
Yeah.
Pero I believe the parties, the councils, and the public should be given certain leeway to comment, especially that an impeachment trial, sabi ng Supreme Court, is a political exercise.
Kaya nga unique siya.
Oo. And speaking of certain leeway, kasi attorney, actually dito lumalabas, nagsha-shine yung ano, no? Yung mga traits and qualities ng mga lawyers. Oo, talagang, and we saw in the past few days that Attorney Kapunan is really a good lawyer. Kaya nga lang, yung nagko-cross-examine from the defense side, pero parang ano, no, parang may mismatch ako nakita between Attorney Ferreira and Attorney Kapunan. Do you think that this is a weakness on the part of the defense panel?
I think it's more of a tactic. So you have to remember that she's defending her client, and I think maybe that's how they wanted to deflect the effect of the evidence on their client. So they have to act that way and try to rattle the witness. Kasi kung napapansin nyo, the witnesses for itong mga auditors, very composed,
Yes.
nakakasagot ng maayos. Maybe it's one way of trying to rattle the witness so that the witness will commit mistakes and answer the wrong way. But I think it's more of a tactic, and it's a matter of how they chose to defend their client.
So you think that Attorney Ferrer will continue to do the cross-examination?
I think that's
By
their
next week.
tactic.
Attorney, should the impeachment court regulate the social media posts of some lawyers, both the defense and the prosecution perhaps, because as it might actually affect or influence the public perception as regards the impeachment case?
I think those involved in the trial, from the prosecution side and the defense side, should cease from making commentaries. Anyway, they have spokespersons who conduct press conferences every after hearing. I think they should ventilate public statements through that press conference to their spokesperson. But of course, insofar as the public is concerned, I don't think that they should be limited as to how they comment on the on the trial.
So proper channel dapat, since they
Yes.
have their own, their respective spokespersons.
And there has to be certain limitations as well, I think, on they can comment, but
Yes.
Depende sa comment.
yes.
Saka not during, not while the trial is going on.
Okay. Sige, okay. The DOJ also has filed 3 counts of grave threats against the Vice President Sara Duterte. And how could this separate criminal case affect the political narrative surrounding the impeachment trial?
Well, legally, it has no effect at all
Right.
to the impeachment trial, because this is a grave threats as defined in the revised penal code. May sariling elemento yan. You have to prove certain elements. While the threat involved in the impeachment trial is not your grave threat in the revised penal code. It's a grave threat in relation to your fitness to hold office. So dapat malinaw yon. So magkaiba yon. The other one is criminal liability. On the other one is the administrative liability of one who is not covered by your regular accountability measures for government officials. So, pagdating sa how it will affect the proceedings, it will not affect at all. Hindi ko lang alam how it will politically play sa public yung pag-file ng case.
Okay. Hindi kaya i-interpret na naman to, syempre on the part of the defense na this is just one of those weapons used by the administration to pressure to prosecute and persecute the vice president. Baka alam mo yun, makadagdag yun sa ganong klaseng narrative ng defense, ano? Pero attorney, no, if I may just I remember when I was with regard to your comment, ang sabing ganon, there is no specific criminal law with regard to grave threat na pinapunish yung nagte-threaten dahil ang threaten niya ay high public officials like the president. Unlike in the United States daw, na meron talagang specific law sa US that punishes this specific kind of threat to their public officials.
Yes, it's not a criminal offense. Sa atin naman, pag hindi defined by law sa criminal act, hindi magiging criminal offense. Pero will this be sufficient as basis for impeachment? Kasi magkaiba naman yun. Because impeachment is you're testing the fitness of
The
public official to
yes.
hold office or not. Now, if there is a threat, is the one making a threat like that, I mean, and admitting it publicly in a press conference, that she already hired somebody to kill the president. That's where you question her fitness to hold office. If she's capable of hiring somebody to kill somebody, the question of fitness to hold office comes in.
Okay. All right. I think we've thoroughly discussed what transpired or somehow touched on the very important issues in the day 14 and 15 of the impeachment trial, attorney. It's getting more critical and crucial as the days go on and on. After the 15 days of testimony, who holds now the momentum? Sino ngayon ang mas nangingibabaw, ang mas nakakalamang, for lack of better term? Is it the prosecution or the defense?
Sa ngayon, as the documents are being presented in court, nakakalamang yung prosecution because they are now pinapakita nila isa-isa how the confidential fund was disbursed. So yun yung danger naman from the defense of not going into stipulation, because now it gives the prosecution the chance to show to the public all the disbursements, all the irregularities that are appearing in the documents, and both evidentiary and publicly, the prosecution has the edge insofar as the case is concerned, because now they can prove their case insofar as the first article of impeachment is concerned. And at the same time, they're playing all of these documents for the public to see.
Yeah.
And be able to show to the public how irregular the disbursements were.
Notwithstanding the effort of the defense panel to debunk.
Yes.
Okay.
Kasi sabi nga the documents speak for themselves.
All right. Maraming salamat, Attorney Ray Cortez. Thank you very much for joining us. Yung mga insights ni Attorney Ray, I'm sure mas marami tayong inuunawan na laymanize yung what transpired in the day 14-15 ng impeachment trial. I myself personally, ang dami ko natutunan. Thank you very much once again for joining us in the show. Of course, Dr. Dennis Coronation, maraming salamat.
Yes.
Parang, parang hindi suki eh.
Oo nga.
Thank you once again. All right, in the end, this is not just about confidential funds, questionable receipts, or a heated exchange inside the impeachment court. This is about power and the limits of that power. When public money is involved, confidentiality cannot mean absolute impunity. When public officials are accused, due process must prevail. And when the country is watching, every side must be held to the same standard. The impeachment trial will run its course. But beyond the politics, beyond the cameras, and beyond the clashes inside the Senate, one principle must remain. Public office is a public trust. In a democracy, no one, no matter how powerful, should be above accountability. I am Ox Ballado, and this is the PH Insider on TV. Good night.